All right, so how do you do an independent administration with a will? Theoretically, it's supposed to be the easiest way to probate an estate, and usually it is. So first off, this is the process of kind of going through and probating an estate with a will. So first, gather the documents. So this can be the most difficult task. So whenever you're trying to kind of put together an estate or do anything, it's finding the things that you need. Of course, we talked about finding the will, but I've provided Form 1 within the book. Here's the book that you can, like I said, you can go to my webpage, you can download this book and you go through, but you can go to Form 1 and Form 1 will walk you through all the documents you need to gather. Now this is your attorney's job. File the application to probate the will and issuance of letters testamentary. That's the application with court. The attorney does that part. And like I said, if you're trying to open up an administration, you're opening up an administration when you're asking for letters. So when you do that process, an attorney needs to do it. Okay, if the will is not self-proved. Now, a lot of people think that a will needs to be notarized. It does not. It just needs to be witnessed by two people in the state of Texas and signed by the testator. In that case, we do what's called a self-proving affidavit. Back in the 1950s, an attorney realized that it would be very easy when he had the witnesses and everybody in the room for the witnesses to fill out separately a self-proving affidavit right then so he could file it with the court when the person passed away. So, and what a self-proving affidavit, all it's doing is saying, I witnessed this person sign this document on this date, and it's signed and it's notarized, and it's needed in the court. So, if the will is not self-proved, we don't have that document. We need to go find the witnesses, or we need a handwritten expert to testify that that is the actual signature of the individual. If a bond is required, okay, you're going to have to go to an insurance company. Insurance companies bond things, or a bonding company, okay? We're trying to avoid this, though, if possible. As one probate judge said, I've never had a bond really pay out. So he didn't like the idea of ever getting a bond to cover anything. They're kind of just a way for middlemen to make some money. If the executor, well, I shouldn't say that. There are bonds that do pay out. It can be useful. But I necessarily would rather have something a little bit more than a bond if someone was going to serve. If an executor, hopefully you picked your executor so you trust them that they don't need a bond. If the executor lives outside the state of Texas, then you need to do an appointment of a registered agent. A person who is not a Texas resident can be an executor of an estate, but they need to have a registered agent. In other words, who do we sue? Who do we send the documents? Who do we serve when we're going to sue this executor? Not every probate judge requires this, but most do require you to attend a prove-up hearing and sign the following documents: a proof of death and other facts, an order admitting a will to probate, and an oath. Those are the things the judge wants when you show up to a probate court. Your attorney should draft those and have them with him. I mean, of course, I forgot a couple of times, more than a couple of times. I forgot to gather these documents, went to the court, and then realized, oh my gosh, I forgot to grab those things. And so then we have to submit it a little bit later. But these are the documents the judge is going to want. Then we need to publish the notice to creditors. Notice to creditors starts all type of requirements. There's a 60-day waiting period from the time that this notice to creditor is published. We file this in the newspaper. We don't do it directly with the creditors, and it's not direct notice. There are different types of notices, but generally this is the step that you have to go through. And you can see form number 2 about how that works. Now, you need to file their IRS, their tax return. You're required to do this. Now, if you are probating the estate of an elderly person that was not filing a tax return, because they usually get money back, you might be able to get away with not doing this. You need to do 2 forms though. It's IRS Form 56, an application for taxpayer identification number that you'll need for the estate. Okay, opening up a checking account if you need to open up a check, in other words, you get a check from somebody, they will not write the check to you as the executor. They're going to write it to the estate. And so you got to go open up an estate checking account. And I know it's annoying. People will try to get those estate checks and then, endorse them over to somebody, and it doesn't work that way. Then this is away from your attorney. If you're an independent, you can go do all the things you need to do. You need to go gather the assets. You can look through form number 3 where I explain how to do that. You'll have to file an inventory appraisement and list of claims within 90 days of receiving the letter. So usually courts make you wait until after the notice to creditor period has passed. Then you can file your inventory. Now, you need to sell the assets of the estate. Okay, so it's your job to go gather the assets and sell it. Now, this starts becoming a problem when people want certain things. I want my mom's lamp. Those become issues. And so you have to deal with those type of situations, okay? But that stuff needs to be sold. Determine how to handle creditors, okay? This becomes where your attorney becomes very valuable. The attorney should know how to handle creditors in their locale or what's going on. There's a lot of times creditors can be avoided. And I personally believe as an executor, you have a duty to try to preserve the estate for the beneficiaries. Now, legally you don't. You can just pay the creditors and just forget it and move on. But I would want my executor for my family, when I'm passing on my estate, to try to avoid paying a creditor versus paying my kids. Now, if they have to pay a creditor, good. However, there are other, especially religious traditions, that the paying of creditors is required. Salvation of an individual is determined upon creditors being made whole. And so in those type of situations, you need to honor the memory and try to have that do what they would want you to do. Distribute the assets to the beneficiaries after the notice of creditor period is run. So after we're done, an executor needs to wrap things up and distribute the estate. A lot of executors will spend a lot of time just holding on to property because they're not getting things done. This is why I like people appointing executors of their own estate as one of the beneficiaries, because there's an incentive to get things done. File federal tax, estate tax return. This might come back, especially after COVID that we're going through right now. They're going to have to start collecting taxes from somebody because they're borrowing trillions of dollars that I don't know how they're ever going to pay back. But the goal is we're going to borrow this money and our future generations will pay back so we can keep living the way that we are. In that case, I imagine the estate tax is going to become the way that they're going to get a lot of money out of people. Wouldn't be surprised to see if we have significant estate tax hikes. File an IRS form 1041 for the estate. Okay, that's what you need to do for an estate. And then cancel bonds if necessary. Closing out an estate. I do not like closing an estate. I can see almost no benefit of doing it. And now I imagine there's another attorney who goes, well, this situation, I've done over 1,000 probates. I have never had an issue of not closing an estate. I have had issues with closing an estate. I didn't close the estate. The other attorney closed the estate. They called me up and I had to reopen it because there was a problem. All right, closing an estate, how would you do it? I put it in here. Okay? Now, that's if you're an independent administrator. This is how you do it. This is how you go through this process and put everything together. That's the general process of how to probate a will. So when we say a probate process, that's what we're talking about, and you can get it in my probate workbook here. Okay?